Today's video is about crimes committed by public officers, and this is your Title 7 of the Book 2 of your Revised Penal Code. Again, my name is Attorney Len, and I passed the 2019 bar exam. So let's start. Okay, so let's start with Article 203, and that is your definition of the public officers. So how can you be considered as a public officer? There are two requisites, and that is number one, you must be taking part in the performance of public functions in the government, or you must be performing in said government or in any of its branches public duties, whether as an employee, agent, or subordinate official of any rank or class. And the second requisite is that the authority to take part in the performance of public functions or to perform public duties must be by direct provision of the law, by popular election, or by appointment by competent authority. So, pag tiningnan mo yung definition ng public officer, it's comprehensive, no? It's quite comprehensive, and it covers all public servant, whether your ranking is in the pinaka-lowest or in pinaka-the highest, like the president. So, pag tinanong ka, who are the public officers, masyadong mahaba pag sinulat mo yung number 1 and number 2, and sa dami ng dapat mong i-memorize, parang malilito ka na. Pero here, just a tip, take note of number 2 because that is the definition na pwede mong isulat doon. Kasi yung number 2, nakasulat na dyan yung number 1. What do I mean by that? Yung sa number 2 nakasulat dyan, person who is performing a public function or a person performing a public duty, and that his authority to perform the public function or the public duty is because of the direct provision of the law, by popular election, or by appointment by a competent authority. That is your definition of the public officer. So, yan yung definition ng public officer. I have here Article 152, or the persons considered in authority or agents of a person in authority, agents of persons in authority. So, tatanungin nyo, attorney, bakit naman meron dyan, attorney, Article 152, nasa Article 203 na tayo. I want you to see the difference between persons in authority and those considered as public officers. Dapat kasi yung iba kasi nalilito sila. Pag tinanong sila, differentiate between persons in authority and public officers, nalito na sila. Ano nga yung difference ng dalawa? So, just take note na yung persons in authority, dapat automatic papasok sa utak nyo na the crime associated in persons in authority and agents of persons in authority are the direct assaults or indirect assaults. And the persons considered persons in authority, they have that power and authority to govern and execute the laws. So, example niyan, yun yung mga barangay chairman. And also, take note na even private individuals can be considered as persons in authority. So, yung mga teachers or professors na hired by the recognized private schools, colleges, and universities are considered by law as persons in authority. We'll go now to agents of a person in authority. So, sino naman yung kinoconsider as agents of a person in authority? According to Article 152, is any person who by direct provision of the law or by election or by appointment by competent authority. Diba familiar yan? Kakabasa pa lang natin yan. Kakasabi pa lang natin na yung authority ng public officer to perform public functions or public duties is because of this 3: election, direct provision of the law, or by appointment. Pero dito sa agents of a person in authority, very specific ang kanyang responsibility, and that person to be considered as an agent of a person in authority is charged with the maintenance of the public order and the protection and security of life and property. So please take note of Article 152, persons in authority and agents of persons in authority. Okay, so the reason why I am really explaining to you the definition of public officers and the definition of persons in authority and agents of persons in authority is because tinatanong siya sa bar exams. So here you have here a 1999 bar examination question where it was asked, although it is only 2%, no, pero again, napaka malaking kasalanan yan. Mortal sin if you cannot answer or you do not know the definition of the public officers. And 1 year apart, year 2000, ayaw din magpahuli, tinanong din the definition of persons in authority. Again, it is only 3%. Pero this is what I have been trying to tell you, na minsan the questions in the bar exams are very codal, can be answered by your codal. Hindi mo na kailangan magbasa ng discussion, ng book, ng explanation, or hindi mo na kailangan malaman yung mga latest jurisprudence because the question is very basic. It can be answered by your codal provision. And usually, most of the time, if you are an examinee, ngarag ka, nakakalimutan mo yung basic. Kinakalimutan mo yung basic, nakalimutan mo yung codal provisions mo. And that is considered a mortal sin, really. If your examiner can see a number 1 question or a kahit number 20 question, very basic lang na question, and you are not able to answer, it will not be a good, you will not be leaving a good impression to your examiner. Sasabihin sa'yo na examiner, nako, napaka-basic naman, hindi pa kayang sagutin. So, siguro, not fit pa to become a lawyer. So, I am trying to emphasize here the importance of really reading your codal. That is really my tip. You read your codal. Okay, so I have here a isang slide, pero there are 3 articles already that are included, and that is from articles 204 to 206, and that is knowingly rendering a just judgment, article 204. Article 205 is about the judgment rendered through negligence, and article 206 is unjust interlocutory order. So, kung ikaw ay first year law student, you do not know the difference between judgment and interlocutory order. Pero if you are already reviewing for the bar exam, or if you are in your 4th year, may idea ka na ano yung difference ng dalawa. But just to give you a layman's difference, no, layman lang para hindi masyadong malalim. Yung judgment kasi is the case is already for decision. Wala nang gagawin in between. So, pag nagbigay na yung judge ng judgment or ng kanyang decision, that is already considered as the final decision. And wala nang magagawa dyan except to go to the next higher body. Or kung example, ang nagbigay dyan is your MTC judge, so next na dyan is your regional trial court. So you go to the higher body. So if it's from RTC, you go to Court of Appeals, depende, no? So that is your judgment, final disposition of your case. Pero pag you talk about interlocutory order, your interlocutory order is different. Ito yung mga nangyayari in betweens. yung from the filing of the between the filing of the case and the final disposition of the case or your judgment, meron dyan mga in-betweens na nangyayari. Like for example, si defendant, lawyer ng defendant, nag-file ng motion to dismiss. So, pag nag-file siya ng motion to dismiss, syempre si judge, kailangan niyang kailangan niyang desisyonan yung motion to dismiss. Hindi naman pwedeng hindi. So, the decision that is being given there is called an interlocutory order. That is your interlocutory order. Another example, if the lawyer would file a motion to inhibit, pinapa-inhibit si judge kasi classmate niya pala yung party o classmate niya si plaintiff. So, dapat doon si judge is sasagutin niya or mag-render siya ng decision dun sa motion to inhibit, and that decision is considered as an interlocutory order. So, that is the layman's difference lang no ng unjust judgment and interlocutory order. If you want to know the difference between the two, pinag-aaralan yan sa remedial law. Ang remedial law ang meron dyan, authority, jurisdiction. So, here, from Articles 204 to 206, iisa ang kanilang requisite. Ang offender, iisa ang offender, and that offender is adjudged. So, this is the reason why I put them together. And in Articles 204 and 205, the common requisite is that number 2 here is the judge rendered a judgment in a case submitted to him for decision, and that judgment is unjust. Sa 204, the reason why it is unjust is because the judge has knowledge. He knows that his judgment is unjust. In 205, hindi niya alam. He has no knowledge. But the reason why his judgment is unjust is because it is a product of the judge's ignorance or inexcusable negligence. Produkto siya ng pagiging ignorante ni judge. Like for example, basic, sino ang may jurisdiction if you will file a Rule 70 or your unlawful detainer or forcible entry? Basic yan, alam yan ng lahat, lalo na mga first year or second year students. Ang jurisdiction yan is with the MTC or the Metropolitan or Municipal Trial Court. So sila ang may jurisdiction yan. Pero final sa RTC, dapat automatic yan. Pag final sa RTC, i-dismiss mo kasi walang jurisdiction ang RTC. Pero si judge, dahil nga ay siguro hindi niya alam because of the ignorance, he tried the case, he heard the case, and he rendered a decision. So that is your example of your 205 or your Article 205. Judgment was rendered through negligence. In Article 206 is your combination of your Article 204 and 205. Here again, the offender is a judge and he performs any of the following acts, and that is number 1, he rendered an unjust interlocutory order, and when he rendered this unjust, he has knowledge. And in letter B, he renders a manifestly unjust interlocutory order or decree, and that is through an excusable negligence or ignorance. So there. Nilagay ko lang to yung Article 204 to 206 para alam nyo lang na meron palang ganitong klaseng offenses or crime. Pero if you will take a look at the bar examinations for the past years, hindi na to tinanong, hindi ko na nga to nakitang tinanong at all eh. Maybe because hindi siya appropriate topic for criminal law. Mas maganda siyang itanong sa legal ethics kasi meron ka ng Code of Judicial Conduct and dun mo to maipapasok. Mas appropriate kung dun mo siya tatanungin. So maybe that is the reason why na Itong Articles 204, 205, 206 is hindi tinatanong sa criminal law. So we go now to Article 207, which is the malicious delay in the administration of justice. So the first requisite is that the offender is also a judge, and there is a proceeding in his court, and he delays the administration of justice, and the delay is malicious. That is, the delay is caused by the judge with that deliberate intent to inflict damage on either party in the case. So, yan yung pinaka mas importanting element, that the judge must have that intent, deliberate intent to inflict damage. So, insofar as Article 207, hindi ko naman siya nakitang tinanong sa bar exam. Okay, so Article 208 is about prevarication. Ang hirap, no? Prevarication. But ito, tinatanong to sa bar exams. I saw this. Ano nga lang yung tanong what is prevarication? So, pag hindi mo alam, parang magugulat ka kasi it sounds like a Latin term. But it is the negligence and the tolerance in the prosecution of offenses. So, there are two acts in punishable under 208, and that is number 1, you maliciously refrain from instituting prosecution against violators of the law, and the second act is you maliciously tolerate the commission of offenses. So here the elements are the following: the offender is a public officer, or he is an officer of the law, and he has the duty to cause the prosecution of or to prosecute offenses. So, ito yung mga fiscal, ito yung mga police, kasi sila yung may jurisdiction ng pagpo-prosecute ng mga laws or ng mga crimes violated. And number 2, there is a dereliction of the duties of his office, and that is while he knows that the crime was committed, that he knows the commission of the crime, he does not cause the prosecution of the criminal, or knowing that a crime is about to be committed, he tolerates its commission. And last requisite is that the offender acts with malice and deliberate intent. Again, there must be that deliberate intent to favor the violation of the law. So that is your Article 208, prosecution of offenses, the negligence and tolerance, or they call that dereliction of duty in the prosecution of offenses. Just take note that this is prevarication. Prevarication. Okay, so we have here a 1991 bar examination question, number 20. A, who is a fiscal, assistant provincial fiscal in Cebu, he was assigned to conduct the PI, or the preliminary investigations of 2 criminal cases. And the first case is rape against X, and the second case is estafa against Y. Unknown to the complainants, both respondents, si X and Y, were schoolmates of the fiscal in their high school years in Lanao del Norte. And despite the overwhelming evidence against X, si fiscal dismissed the rape case. And despite also the overwhelming evidence against Y, si fiscal, he did not file the information for estafa because according to him, the folder of the case to which were attached the dishonored checks and other documents offered in evidence by the complainant was stolen. So contrary to such claim, yung folder pala was kept in a safe in his house. So what offenses or offense under the titles and crimes committed by public officers of Book 2 of the RPC may A be charged with? Ang ganda nitong question na to kasi binigyan ka pa niya ng ng tip kung ano yung crime. In-specific niya na crimes committed by public officers. Yung ibang question hindi siya nagaganyan. Pero the answer here is Article 208 is violated, and that is you maliciously refrain from instituting prosecution for punishment of the violators of the law. And likewise, the prosecutor is likewise liable under Article 226 for removing and canceling public document entrusted to his custody. The reason why I am including this bar question, kahit na it was asked in 1991, masyado nang matagal, just to prove a point, no, na again, you go back to your caudal. Always go back to your caudal. Hindi mo kailangan minsan ng discussions ng book. Hindi mo kailangan mag-dig deeper. You have to know the latest jurisprudence because ang sagot na sa caudal lang eh. Like for this example, you just know the requisites, which is found in your caudal actually. Just know the requisites, and when you read the facts of the problem, i-match mo lang siya dun sa requisites ng batas. So pag pumasok siya sa requisites, and that is your answer. No need to go deeper, no need to know the latest jurisprudence, no need to explain because your caudal will do the explanation for you. So this is an example. So I hope that you will really put into your heart my tip na read always your caudal provisions. So Article 209 is about betrayal of trust by an attorney or a solicitor, and that is the revelation of secrets. So there are 3 acts punished as betrayal of trust by attorney, and that number 1 is when the attorney causes damage to his client by any malicious breach of professional duty or by inexcusable negligence or ignorance. Example again ng ignorance is yung si lawyer final niya, will go back to Rule 70. Si lawyer final niya yung unlawful detainer or forcible entry sa RTC instead of MTC. Nako, napakalaking kasalanan yan because we all know that it is the MTC which has the jurisdiction over cases for forcible entry and unlawful detainer. So that is an example of your inexcusable negligence or ignorance. Another act that is being punished is revealing any of the secrets of his client learned by him in his professional capacity. And in this one, damage is not necessary. So meron ka ditong chismosong abogado, kinikwento lahat ng sekreto ni kliyente, hindi lang sa kanyang asawa, pati dun sa kanilang kapitbahay. So that is a big no-no. And number 3 is undertaking the defense of the opposing counsel in the same case without the consent of his first client after having undertaken the defense of said first client or after having received confidential information from said client. Itong number 3, makikita mo to sa legal ethics. Allowed ka naman to take the case of another party, pero may mga requisites yan, may mga requirement. And regarding Article 209, again, no, hindi ko to masyadong nakikita na tinatanong sa criminal law because primarily this is a proper topic for your legal ethics, yung mga revelation of secrets ng abogado. Ang mas tinatakal to sa legal ethics kung ano ang mga dapat gagawin ng isang lawyer at ano ang kanyang mga do's and don'ts. So it's good to know that Article 209 is there is such a crime as revelation of secrets or betrayal of trust. Good to know. Pero again, if you want to study this, you relate this always to your legal ethics. Okay, so we'll go to Article 212, and that is your corruption of public officials. Maaring magtataka kayo, no, bakit inuna ko si Article 212 instead of Article 210, which is your direct bribery. There is a reason for that. Again, gusto kong ipakita sa inyo na when the examiner wants to ask you about direct bribery or indirect bribery, they most of the time go hand in hand with Article 212, and that is your corruption of public officials. Parang mag-twin sila, no? Parang hindi mo pwedeng tanungin lang si direct bribery or si indirect bribery na hindi mo rin tatanungin si corruption of public officials. So, later on in the next slides, makikita nyo yung point na pinuprove ko. So, we'll go first to the requisites, and that is number 1 here, the offender, he makes offer, or the offender promises or give gifts or presents to a public officer, and that offers or those promises or those gifts or presents given to a public office is under that circumstance that will make the public officer liable for direct bribery or indirect bribery. Ang offender kasi sa corruption of public officer is yung giver ng gifts or the offerer of promise. So, siya yung offender, hindi yung public officer. So, take note of that, ha? Take note of that. Take note of Article 212 lang muna. Okay, so this is your Article 210, and that is the direct bribery. Favorite topic sa bar exam. As in. So, there are 3 acts that is being considered as direct bribery, and I want you to take note of the following terms. You take note of the following terms kasi yan yung magdi-differentiate ng direct bribery from indirect bribery. So, number 1 act is agree. Take note of the term agree. So, when a public officer agrees to perform or performing in consideration of any offer, promise, gift, or present, and that act is constituting a crime in connection with the performance of his official duties, that is considered as a direct bribery. So again, take note of the word agree, and the act would constitute a crime. So those are the 2 words that I want you to remember. Second, when the public officer accepts a gift, he accepting a gift in consideration of the execution of an act which does not constitute a crime in connection with the performance of his official duty. So the 2 terms that I want you to remember is he accepts a gift, although by accepting the gift, it is not considered or it does not constitute a crime. And the last act being punished as direct bribery is he agrees to refrain, the public officer agrees to refrain or by refraining from doing something which is his official duty to do in consideration of gift or promise. So again, the word that you have to remember is agree, refrain from doing something. So take note of those terms, ha? Agree, accepts, and it constitutes a crime, it does not constitute a crime, and he refrains. So what are the elements of the direct bribery? So first, you have here that the offender must be a public officer, and within the definition of Article 203, we already know who are the considered as public officers. Second element is that the offender, he accepts an offer or promise or receives a gift or present by himself or through another. So take note, by himself or through another person. And number 3, such offer or promise be accepted or gift or present received by the public officer with a view to committing some crime or in consideration of the execution of an act which does not constitute a crime, but the act must be unjust, or he refrains from doing something which it is his official duty to do. And the last element is that the act which the offender agrees to perform or which he executes be connected. Oh, yan, importante yan. It is connected with the performance of his official duties. So, kung binabribe ang isang public officer, like for example, binabribe siya na binabribe, if you are a BIR official, ang pang-bribe sa'yo is wag kang mag-file ng kaso, wag kang mag-file ng kaso, wag kang mag-file ng criminal case. Pero ang trabaho naman ni public officer is siya yung in charge dun sa computation ng mga taxes. Parang walang connection. Kaya importante yung it must be in connection with the performance of his official duties. So I have here a 1975 bar examination question, number 11. Luma na siya, pero maganda siya. Maganda yung bar exam na question na to. A municipal judge, in consideration of the 1,000 given to him by the complainant, masyadong maliit pa yung amount because this was asked in 1975. And at the latter's request, he rendered a decision convicting the accused. If you were the fiscal, would you prosecute the judge for bribery or for knowingly rendering an unjust judgment? So, that is the reason why gusto ko yung question na to, kasi there are two crimes already that are involved, and that is bribery or knowingly rendering an unjust judgment. So, malalaman mo talaga dito kung yung examinee or yung estudyante is nag-aral, alam ba niya. So, the answer here is, if I were the fiscal, I would prosecute him for bribery. Elements of the bribery: he received money from the complainant, and at the complainant's request, he rendered a decision convicting the accused. And the judge did that for a consideration, and he performed an act related to the duties of his office. So, such constitutes bribery. The facts of the case do not sustain the offense of knowingly rendering unjust judgment. Bakit? Because firstly, it does not appear that the judgment is unjust, that is, it is against the law and the evidence. And secondly, even if it is assumed it is unjust, it also does not appear that the judge rendered the judgment knowing it is unjust, that is, maliciously and in bad faith. Kasi dun sa knowingly rendering an unjust judgment, if you can recall, ang importanteng element dun is the judge must have that knowledge that he is rendering an unjust judgment. That is your Article 204. So, there. Okay, so you have a 1983 bar exams, number 14. Ito na yung sinasabi ko na yung bribery and corruption of public official, they go hand in hand. Para silang twins, dapat magkasama palagi. So, here, there is a building contractor. He offered to bribe an engineer employed in the Ministry of Public Works and Highways. So, again, luma yung bar exam question, no? It was asked in 1983, kaya ministry pa. Pero right now, it is called DPWH. The latter refused, so si engineer, he refused the offer, not because of moral scruples, but because he thought he was being entrapped. So, what are the crimes or crime, if any, under the RPC were committed, and by whom? You give the basis of the liability or the non-liability of both the building contractor and the engineer. So, what is your answer? Your answer is the building contractor is liable only for attempted. Take note of attempted corruption of a public officer. The reason for that is because the bribe offered was not accepted by the engineer of the DPWH, who is a public officer. Kaya siya attempted. Alam nyo naman siguro yung difference ng attempted, frustrated, and consummated. So, here, there is such an animal as attempted corruption of a public officer. How about the engineer? Si engineer ba is liable? The engineer does not incur any criminal liability. The reason for the refusal is immaterial. Ang ganda, no? Another bar exam tip. Makikita nyo yung sa answer is very simple and direct to the point and walang paligoy-ligoy. In fact, if you can see, there are only 3 sentences, and that's it. So, hindi mo kailangan pahabain yan, hindi mo kailangan yan gawing 2 paragraphs. Sa dami ng babasahin ni examiner, mahihilo siya. At saka pag mas mahaba, mas marami kang mali. So, here, very direct. Pero, kung direct ka, it presupposes that you know also. So, just a tip, no, you study your bar exams. Study always your bar exams para magkakaroon ka lang ng idea how to answer. And also, you practice also answering your bar exams. Sa kaka-study mo ng mga bar exams, makikita mo yung approach. Meron dun iba na mahabang sumagot, meron naman na very direct to the point, 4 sentences, 3 sentences, tapos na. Pero, still, the examiner would give them a full point, like a 5, if it's a 5-point question, 5 ang bibigay na examiner because nasa pool niya lahat. Ang sinagot niya is the provision lang itself and a little explanation, and that's it. No need to elaborate, no need to add more. So, here, another bar examination question that you can relate to. 2001 bar examination question, number 10. You have here an ejectment case filed by Plaintiff Estrada versus the defendant Ablan. And the sheriff here, Rivas, whose name is Rivas, he received from the RTC clerk of court a writ of execution. And the judgment is in favor of the plaintiff, Estrada. So what the sheriff did is he went to the office of Estrada. He went to the lawyer's office of the plaintiff, Estrada, and there he was given the necessary amounts constituting the sheriff's fees and expenses for execution in the total amount of 550 pesos. Aside from the 550 pesos, binigyan din siya ng plaintiff at ni lawyer ng another amount of 2,000 pesos. The purpose of the 2,000 pesos is he will promptly enforce the writ of execution. So the writ was successfully enforced. Letter A question is, what crime, if any, did the sheriff commit? So the answer there is the sheriff committed the crime of direct bribery under the second paragraph of Article 210, since the 2,000 pesos was received by him in consideration of the prompt enforcement of the writ of execution, which is his official duty to do. So ano ba yung second paragraph? Diba, diniscuss na natin yon. Yung second paragraph is about accepting a gift. Diba, I told you to take note of the word accept. Accepting a gift. Although by accepting a gift, it does not constitute a crime. The first act is agree, but it constitutes a crime. The second is you accept a gift, but it does not constitute a crime. So here, that is your example. Letter B is, was there any crime committed by the plaintiff Estrada and her lawyer, and if so, what crime? So on the part of the plaintiff and her lawyer as a giver of the bribe money, the crime committed is corruption of public officials under Article 212 of the Revised Penal Code. So we will go to Article 211, favorite also, bar topic. Indirect bribery. So the elements are, the offender is a public officer, and then he accepts gifts, and the gifts are offered to him by reason of his office. We will now distinguish direct bribery from indirect bribery. Ano ba yung difference ng dalawa? Their common element here in direct bribery and indirect bribery is si public officer, they both receive gifts, no? Si public officer tumanggap dito ng regalo. Pero ang diferensya sa direct bribery, there is an agreement between the public officer and the giver of the gifts or the promise. Meron silang pag-uusap at meron silang agreement. In indirect bribery, that agreement does not exist. No such agreement exists. Third difference is indirect bribery. Si offender or si the public officer, again, no, yung sinabi kong take note of the word agree. He agrees to perform, or he performs an act, or he refrains from doing something, and the reason he is doing that is because of the gift or the promise. Pero pag pinag-uusapan mo si indirect bribery, it is not necessary that the public officer should do any particular act or even promise to do an act. The only reason why the public officer is liable for indirect bribery is because he accepted or he accepts gifts offered to him by reason of his office. So yun lang. Kaya lang siya liable is because he accepts or he accepted gifts that were being offered to him by reason of his office. So those are the differences between direct bribery and indirect bribery. Example ng indirect bribery, 1997 bar examination question, number 16. Si A here is a private complainant in a murder case pending before the RTC judge. Ginawa ni A, he gave the judge a Christmas gift. Yung Christmas gift is only a big basket of assorted canned goods and bottles of expensive wines that is only worth 10,000 pesos. The judge accepted the gift knowing that it came from the private complainant. So what crimes or crime, if any, were committed by the judge? So what is the answer? The judge committed the crime of indirect bribery. The gift was offered to the judge by reason of his office. And in addition, meron pang ibang kasalanan. No? The judge will be liable for the violation of PD 46, which punishes the receiving of gifts by public officials and employees on occasions like Christmas. So, makikita nyo, wala namang agreement si judge at saka si private complainant. Ang ginawa lang ni judge is tinanggap lang niya yung binigay sa kanya na regalo. So, that is already considered as an indirect bribery. We have here a 1993 bar examination question, number 3. Ito, combination to ng indirect bribery and corruption of public official. So, here you have a case, a civil case between Maricel, the plaintiff, and Julie, the defendant. So, the judge here, si Arevalo, he heard a civil case and he received a gift coming from the plaintiff, si Maricel. Pero, kahit nakatanggap siya ng regalo coming from the plaintiff, yung decision na na-render niya is in favor of the defendant, kay Julie. So, sa ganun bang pagkakataon is the judge is still criminally liable, and for what crime? The answer is, si judge is still liable for indirect bribery and violation of the code of conduct and ethical standards. Kasi yung reason is he still accepted, 'di ba, yung elements talaga ng indirect bribery na the public officer will accept a gift and the said gifts are offered to him by reason of his office. Napaka-simple lang ng elements or ng requisites and you are liable already for indirect bribery. And si Maricel, si plaintiff, is also liable for corruption of public officer. So there is an Article 211-A, and that is your qualified bribery. So aside from direct bribery, indirect bribery, meron ding qualified bribery. So kailan ba siya nagiging qualified bribery? The elements are the following. The offender is a public officer and he is entrusted with the law enforcement, and he refrains from arresting or prosecuting an offender who has committed a crime punishable by reclusion perpetua and or death. And the last element is the offender refrains from arresting or prosecuting in consideration, again, of any offer, the promise, the gift, or the present. So, kailan ba siya nagiging qualified bribery? Take note lang na dapat yung crime na nakomit nung giver is punishable by reclusion perpetua and or death. Yan yung yan yung element na magiging qualified bribery siya. So kung hindi punishable ng reclusion perpetua and or death, you will consider that as direct bribery or indirect bribery for that matter. So take note of Article 211-A. Yes, tinatanong din siya sa bar exam. We'll go now to Article 213, and that is your fraud against public treasury. Dun sa Article 213, there are two crimes here, and that is your fraud against public treasury and illegal exactions. We will discuss in this slide the fraud against public treasury. But before we go, I did not discuss on purpose yung Anti-Graft and Corrupt Practices Act, because I will make a separate video for that. Yung mga special laws, special penal laws, I will make a separate video kasi masyado nang mahaba at saka para hindi kayo magulo. Pag hinanap nyo, madaling i-click na ito pala yung topic na about Anti-Graft and Corrupt Practices Act. So, here, what are the elements? The number one is that the offender is a public officer. And number two, he should have taken advantage of his office, and that is he intervened in the transaction in his official capacity, and he entered into an agreement with any interested party or speculator, or made use of any other scheme with regard to the furnishing of supplies, the making of contracts, the adjustment or settlement of accounts relating to public property or funds. And the last element, important element, is the accused or the public officer has that intention to defraud the government. Tinatanong sa bar exam? Yes, tinatanong din sa bar exam. We have here a 1988 bar examination question about number 12, about Article 213. So, here is a city official who ordered 1 million pesos worth of t-shirt at public expense for the underprivileged residents of his city. And after full payment with city funds was made, it was discovered that only 1/4, so only 250,000 worth of t-shirts had been delivered, and yung rest or the 750,000 pesos were so-called ghost deliveries. So the question here is, what is the crime committed by the city official? And the answer given by the UP Law Center is the city official is liable for violation of Article 213 of the RPC. Pero me, personally, I do not agree with the answer of the UP Law Center. Kasi if you look at the requisites of Article 213, di ba, kakadiscuss lang natin. Sinabi doon na number 2 requisite is that the public officer should have taken advantage of his office. What is the meaning of that? The public officer, in this case, the city official, he should have intervened in the transaction in his official capacity. And number 4 element there is that city official must have that intention to defraud the government. Pag binasa mo yung question, there are no facts that would indicate na si city official took advantage of his official position. He took advantage of his official capacity, and there are also no facts that would indicate that the city official has that intention to defraud the government. So why would you assume a fact which was not written in the question? So in that case, hindi siya pwedeng maging liable for violation of Article 213 simply because the elements of Article 213 are not present. And you cannot assume a fact which is not written. That is the reason why I am not agreeing with the answer of the UP Law Center. Malinaw naman yung facts eh. So, hindi ka pwedeng magdagdag. Hindi ka rin pwedeng magbawas. So, ito yung example na, again, gamitin mo yung knowledge mo, i-try mo yung elements, tapos pag nabasa mo yung answer ng UP Law Center, sasabihin mo, parang mali yata. And, you go with your gut kasi mas alam mo eh. Just be firm with your reasoning, and for that, the examiner will give you your points. Yan naman ang purpose ng bar exam. You know how to defend your answer. You know how to defend your client. Okay, so this is your illegal exactions. The elements are the following. Number 1, the offender is a public officer, and that public officer has that responsibility, or he is entrusted with the collection of the taxes, the licenses, the fees, and other imposts. And second, he is guilty of any of the following acts or omissions, and that is number 1, he demands directly or indirectly the payment of sums different from or mas mataas, larger than those authorized by law. Second is he fails voluntarily, take note of the word voluntarily, to issue a receipt as provided by law for any sum of money collected by him officially. And last is he collects or receives directly or indirectly by way of payment or otherwise things or objects of a nature that is different from that provided by law. So this is your Article 213, illegal exactions. Tinatanong ba yan sa bar exams, attorney? Yes po, tinatanong din po ito sa bar exams. Yan. 1975, although luma na siya, no, tinanong. Number 9. There was this municipal treasurer who received 500 pesos from a taxpayer, but he neglected to issue the corresponding receipt. Is he criminally liable? Why? Answer: the law provides that for the failure of the municipal treasurer to issue a receipt for the amount paid as a tax must be voluntary in order that illegal execution may be committed. Diba? I told you that you take note of the word voluntary. Pero sa problem, ang sinabi niya is he neglected. So the mere fact, however, that he neglected to issue the receipt would not make him necessarily liable, because in a crime against public officers like illegal exaction, negligence is not mere laxity, but laxity in the performance of duties approximating fraud and malice, or the negligence must be shown to be positively and clearly inexcusable. So, there. Take note of the word talaga, yung failing voluntarily to issue a receipt. Dapat voluntary, hindi yung na-neglect lang ni public officer. We have here Article 213, 1977 bar examination, number 8, letter B. There is this teller of the provincial treasurer's office. He told the landowner that yung amilyar, the real estate tax due is 500 pesos, pero the truth is it is only 400 pesos. So the landowner, he paid as told, and in order that the landowner will not discover the excess, the teller made it appear in the original of the official receipt to be given to the landowner that 500 pesos was paid, but in the duplicate left with him, the true amount of 400 was stated. Thereafter, the teller misappropriated the entire amount of 500 pesos, and assuming that you are the investigating fiscal, what crime will you file against the teller? State your reasons. So, there are 3 crimes na pwedeng i-file sa teller, illegal exaction, falsification of public document, and malversation. Pero we'll focus lang muna doon sa illegal exaction. Diba? We just discussed na there are 3 ways to commit illegal exaction, and one of that is if the public officer would demand directly or indirectly the payment of sums which is different from or larger than those authorized by law. So, ito yung nangyari dito. Si teller, when he told the landowner that the real estate tax due is 500, pero yung totoo, it was only 400 pesos, the teller collected an amount bigger than that authorized by law. The teller is a public officer, and in view of his duties, he is entrusted with the collection of taxes. Therefore, illegal exaction is committed. Article 214 is about other frauds. The offender here is a public officer again, and he takes advantage of his official position, and he commits any of the frauds or deceits enumerated in Articles 315 to 318. So, ano ba yung 315 to 318? Those are estafa, other forms of swindling, swindling a minor, and other deceits. So, that is your Article 214. Hindi ko din to masyadong nakita sa mga bar exams. Pero, just take note that there is Article 214. So, we have here Article 215, the prohibited transactions. The offender here is an appointive public officer. Take note of the word appointive as different as opposed to elective. Yung appointive, ito yung mga tawag dito, ina-appoint lang, like your mga secretaries ng DPWH, si Secretary Villar. So, they are at the whims of the appointing officer. And he becomes interested directly or indirectly in any transaction of exchange or speculation, and the transaction takes place within the territory subject to his jurisdiction, and he becomes interested in the transaction during his incumbency. Yung Article 215, parang mas makikita mo to sa Anti-Graft and Corrupt Practices Act. The reason why siguro hindi na rin to masyadong tinatanong sa bar exam, yung particularly Article 215 is nasasakop siya ng ibang batas, like what I said, yung Anti-Graft and Corrupt Practices Act, and also in your political law. Article 216 is about the possession of prohibited interest by a public officer. Before I explain this article, let me just thank all of you who are subscribing my channel and who are watching also my channel. Nakakataba ng puso that you are watching my channel, and if you are going to leave a comment, so please do so. Kasi it will inspire me to do more videos. Kasi sa totoo lang, kumakain din siya ng oras ko, yung recording, kumakain din siya ng oras ko. Pero, if I can help you in your dream of becoming a lawyer, so, mas fulfilling yon on my part. So, again, if you have friends who have not heard of me, or if you have relatives who have these plans of taking the 2021 bar examinations or the bar examinations in the future, if you can tell them about me, thank you very much in advance. So here is your Article 216, and that is the persons here. There are the persons liable for the possession of the prohibited interest, and that is number 1 is the public officer, number 2 are the experts, arbitrators, and the private accountants, and the guardian and executor. So for a public officer, he must directly or indirectly became interested in any contract or business in which it was his official duty to intervene. Ito, ano na to, makikita mo to sa political law din, constitutional law, meron to. And then, the experts, arbitrators, and private accountants who, in like manner, took part in any contract or transaction connected with the estate or property in the appraisal, distribution, or adjudication of which they had acted. And the last is the guardian and the executor with respect to the property belonging to their wards or the estate. Yan, meron yan sa remedial law. So, with respect to Article 216, parang hindi ko naman siya napansin sa bar exam. Maybe because yung, like what I said, yung public officer, makikita mo yan sa political law, yung expert arbitrators and private accountants, meron yan sa civil law, and your guardian and executor, meron yan sa remedial law. So, parang dun na yan tinatanong, hindi na dito sa criminal law. So, this is the end of the part 1 of the yung crimes committed by public officers. I decided to split them into 2 videos kasi hindi kayang isang video lang magiging masyadong mahaba. Kailangan kasing himay-himayin yung bawat crimes, and marami ding crimes na ka-indicate sa crimes committed by public officers. So that is the reason why there is a part 2 of this. So please watch out for the part 2 of the crimes committed by the public officer. So this is the end of your video. Thank you very much again for watching, and if you can tell your friends about me, please do so. So good day, and God bless us all.